Accordingly, a balance had to be struck to avert violent revolutions against abusive amendments. In an article, The Politics of Constitutional Change in Kenya Since Independence, 1963 to 1969, Professor Okoth Ogendo underscores the fate of post-independence constitutions. He writes, "Constitutional systems in Anglophone Africa have not had a happy history, especially during the last decade. Almost without exception, the independence documents have either ended up in military dustbins or have undergone change so profound and rapid as to alter their value, content, and significance beyond recognizance." End of quote. I hear the good professor saying the independence constitution was so badly dismembered, and that if they did not suffer the fate of dismemberment, it was more likely that the constitution would find their way into dustbins following military coups. The writings of Professor Okoth Ogendo echo the profound words of John F. Kennedy in 1962 when he stated, and I quote, "Those who make peaceful revolution impossible will make violent revolution inevitable." End of quote. It is no secret that the framers of our 2010 Constitution struck a balance between stability and instability by providing for amendments in Chapter 16 of the 2010 Constitution, and this being the supreme law of the land, it was desirable to give it a more stable character and free it from hyper-amendments. This is important as no society is static, and what is good for one generation may not necessarily be good for the next. In an article entitled "No Generation Has the Right to Impose Its Own Values and Political Principles on a Later Generation" by Professor Fatuma, he cites another scholar, Colvin De Silva, who states as follows: "Constitutions are made in terms of the stage of development at which any given society or country has arrived. In terms of that stage of development, it looks upon things, and for any generation of people to imagine that it can so completely project itself into infinity of the future, so as to be able to decide its own generation that it will constrain a future generation or generations forever within the confines of its own postulates, is to make a mistake of thinking that any human collectivity is the equivalent of the divinity." End of quote. He concludes, "It is unlikely that the framers of the new or revised African constitutions wanted to prevent future generations from repealing these constitutions. A constituent body is omnipotent only to the extent that it has no power to destroy or limit the omnipotence of a future constituent body. In short, the present and future generations should not be ruled by the dead hand of their ancestors." End of quote. I think it behooves us to recognize that in spite of the supremacy of constitutions, we cannot and should never legislate from the graves, what Professor Fatuma refers to as the dead hand. We cannot possibly shackle future generations but by what we consider to be noble today. The other troubling aspect of the impugned judgment is that the High Court came to the conclusion that whatever is amendable will be decided on a case-by-case basis. And this is what they said: whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, the history of the clause and the constitutional history, and other non-legal consideration permitted by our canon of constitutional interpretation principles." End of quote. The above finding, in my view, poses difficult questions. Who is to carry out the fact-intensive determination? And at what stage in the process of constitutional change? The appellants told us, and rightly so in my view, that in terms of seeking an advisory opinion, Wanjiku has no place, as by dint of Article 163, Sub-Article 6, this is a preserve of the national government, a state organ, or a county government. I reproduce therein the provision of that article. Since Wanjiku does not have the luxury of approaching the Supreme Court under Article 163, Sub-Article 6, how does Wanjiku get to have an issue subjected to fact-intensive determination? Sight should also not be lost that judges, being human, are not infallible, and they should not arrogate unto themselves the unfettered power to validate or invalidate amendments on the basis that they are eternal causes from their preferred reading of the Constitution. If for a moment we were to find that judges are fallible, where will be the unwritten constraint? The absence of constraint, no doubt, leads to uncertainty and absurdity. In an article by Adan Kasia Abebe entitled "The Substantive Validity of a Constitutional Amendment in South Africa," appearing in a South African journal, I'll just read part of what he said in that article. The idea of a judicially enforceable implied limits on the power of constitutional amendment is particularly unacceptable in cases where a constitution explicitly outlines the fundamental principles and subjects such principles to amendment, as is the case in South Africa. In the absence of a clearly defined and enforceable substantive limits, the judicial control of constitutional amendments will lead to a situation where courts effectively arrogate the role of the people and their elected representatives in defining a polity's fundamental values over which there may be a reasonable disagreement. The absence of clearly defined limits also means that every constitutional judge will have his or her own list of what is basic and what is not. The judicial power to define basic social and political values belies the ideal that courts should merely apply settled rules and principles and not discover some vague fundamental values to invalidate the best judgments of the overwhelming majority of the political representative. In the absence of clearly established substantive limits and an explicit jurisdiction to enforce substantive limits on constitutional amendments, the power and responsibility of ensuring compliance with any desirable substantive limits lies beyond the courtroom. Only the democratic process or a revolution could legitimately and effectively stymie any attempt to legitimize undemocratic behavior through constitutional amendments, end of quote. Similar sentiments on infallibility of judges are expressed in an article entitled "The Conundrum of Unconstitutional Constitutional Amendments" by Paul Jen Yap, and he states, "The people may not always be right, for popular sovereignty is not an absolute guarantee of substantive justice, but neither are judges infallible in their moral deliberations. In these circumstances, the judiciary must cede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by the separation of governmental powers," end of quote. In my view, it is not correct to elevate judges to the status of demigods, and just as it is possible to have a distrustful and rogue parliament, it is also possible to have a rogue and distrustful judiciary, more so bearing in mind that the latter are not elected as the people's representative. I know that as Kenyans, we love to demonize our elected political leaders. We do this all the time, but rarely do we stop to remember we get the leaders we deserve. I am therefore of the persuasion that the contest of what is amendable and what is not should not be left to be a matter of judicial innovation. Judges, just like parliamentarians, cannot assume supremacy over all others, as indeed it is the people who are sovereign. Article 1, Sub-Article 1 of the 2010 Constitution screams out, all sovereign power belongs to the people of Kenya and shall be exercised in accordance with this Constitution. End of quote. The people of Kenya, in the exercise of their constituent power in a referendum, voted for the amendment of the pre-2010 Constitution. In came the 2010 Constitution with provisions on how it can be amended in accordance with this Constitution. On the ultimate expression of the will of people, I find an article by Yaniv Rosnai and constitutional amendments to be telling. And allow me to read this passage. He says, "And constitutional amendment seems puzzling. The Constitution is the highest positive legal norm. The power to amend the Constitution presupposes the same kind of power as the one to constitute a Constitution. It is a supreme power within the legal system, and as such, it can reach every rule or principle of the legal system. If this power is indeed supreme, how can it limit itself? If it is limited, how can it be supreme? This is the legal equivalent of the paradox of omnipotence. Can an omnipotent entity bind itself? Both positive and negative answers to these questions lead to the conclusion that it is not omnipotent. Moreover, if the amendment power is a kind of constituent power, then it remains unclear why a prior manifestation of that power prevails over the later exercise of a similar power. Quite the reverse, according to the principle, a later norm should prevail over a conflicting earlier norm of the same normative status. Finally, the Constitution, which expresses the people's sovereign power, binds and guides ordinary law, which expresses the Parliament's ordinary power. The common meaning of unconstitutionality is that an ordinary law, inferior to and bound by the Constitution, violates it. How can unconstitutionality refer to an act carrying the same normative status as the Constitution itself? The question posed by Yaniv Rosnai is, the question that he has posed, why a prior manifestation of that power prevails over the latter exercise of a similar power, underscores the people's will to amend the Constitution without a prior manifestation of that power prevailing over the subsequent exercise of a similar power. Suffice to state that in the 2010 constitutions, Kenyans recognize their constitutional right to amend the Constitution as long as this is done in the manner provided in the Constitution. If perchance the framers of our Constitution had intended that there be a limitation on the power of amendment, they would have provided as much. There are no such limitations in Chapter 16 of the Constitution. And at the risk of being repetitive, I reiterate there is no clause in the 2010 Constitution that prohibits amendments, but there is an inbuilt mechanism that provides safeguards, and I am of the persuasion that the High Court erred in imposing another hurdle on the basis of an implied provision anchored on the spirit or overarching theme of the Constitution. In my view, the High Court erred in invoking the spirit of the Constitution without the need to do so, given the clear and ambiguous language of the 2010 Constitution on amendments. It is also my view, as explained above, that the findings of the High Court were not supported by the context, structure, and history of the Constitution 2010. The upshot of the above analysis is that the appellant's appeal on the non-applicability of the basic structure is for allowing. However, this is subject to the majority decision of this court. So much as relates to the issue of the basic structure. The next, I shall then proceed now to look at the role of the President, the role of His Excellency the President in the BBI process. I think for a start, for me, the beginning point is Article 131(2)(c) of the Constitution, which requires the President to promote and enhance the unity of the nation. And with the noble intention, on 9th of March 2018, His Excellency the President, Uhuru Muigai Kenyatta, held talks with the former Prime Minister Raila Odinga that culminated in what is now commonly referred to as a handshake. The intention of the handshake was to bring to an end the political disharmony, demonstration process, and disgruntlements that arose with the outcome of the presidential elections held in August 2017. The handshake would then become a political tool to calm the nation that was deeply divided and to allow for consensus building. I think the history about the formation of the task force as well as the formation of the steering committee were well captured in the introductory part of this judgment that was done by the President of the court. And I will not repeat that. But suffice to state that it is not in dispute that the Task Force on Building Bridges to Unity Advisory Task Force was appointed by His Excellency on 24th of May 2018, and subsequently this gave way to the Steering Committee, and that the process leading up to the formulation of the Constitution of Kenya Amendment Bill 2010 in my view, was largely driven by the executive, as it is difficult to truncate the BBI task force and the BBI steering committee from the submissions of the letter by Honorable Junet Mohammed and Honorable Waweru as promoters of the Constitution of Kenya Amendment Bill 2020. It is clear that one thing led to the other until the culmination of the letter of 18th November 2020 by Honorable Junet Mohammed and Waweru and Honorable Waweri to the Iebc seeking approval of the format to be used in the collection of signatures. Article 256 and 257 of the Constitution provide for amendments by way of a parliamentary initiative and not a popular initiative. The proposals by Honorable Junet and Honorable Waweru would best have been channeled through a parliamentary process, as they were heavily laden with the executive arm. The route of popular initiative was not open to them, as this was not a Wanjiku-driven process. There was an alternative argument that although His Excellency the President Uhuru Kenyatta, was not a promoter of the Constitution of Kenya Amendment Bill, it was contended that nothing stops him from being a promoter of a popular initiative in his own personal capacity, as it may well be possible that a president may find himself in a peculiar position that she does not enjoy the support of Parliament, hence he would be locked out of both the parliamentary as well as the popular initiative. Mr. Kiragu Kimani, Senior Counsel, while urging the appeal on behalf of His Excellency, submitted that the President under Article 38 of the Constitution of Kenya has a right to make political choices just like any other Kenyan, and that the term initiator that was used by the High Court in reference to His Excellency the President was not recognized in the Constitution, and that there was nothing that barred the President from being a promoter of the bill, that the President has a right to campaign for any political party or cause. Further, that Article 12 of the Constitution provides that every citizen is entitled to the rights, privileges, and benefits of citizenship, subject to the limits provided or permitted by this Constitution. End of quote. It was contended that if we were to find that His Excellency the President in his personal capacity cannot use the route of a popular initiative, then this would be tantamount to denying him his rights as a citizen. In my view, the balancing of the rights of a sitting president pose a challenge, as it is difficult to make a demarcation when a president is acting in his personal capacity vis-a-vis his official capacity. Can a president cease to be a president without handing over power during the tenure of his office? In the circumstances of this case, we were told that His Excellency Honorable Uhuru Kenyatta was not the promoter. Indeed, the High Court acknowledged that His Excellency the President was not the promoter, and they coined the term initiator, a term not anywhere in the constitutional amendment process. Be that as it may, the question to be answered is whether His Excellency the President can be a promoter of an amendment bill. In my view, I would liken the situation to that obtaining in the military, where military personnel are often said to be children of a lesser God, to the extent that some of their fundamental rights are limited by virtue of their joining the military. Regrettably, by conduct, there are limitations placed on public officers as to what they can do and what they cannot do. I liken the position of His Excellency the President to that of a judge, where one is a judge 24/7, and it is difficult to say when he or she is not acting in his official capacity. Given the above, it is my humble view that His Excellency the President cannot therefore be a Wanjiku for the purposes of Article 257 of the Constitution, and to this extent I'm in agreement with the High Court findings that His Excellency the President cannot initiate changes to the Constitution through a popular initiative as provided in Article 257. The third item that I will go into is the issue of the legality of the BBI Task Force and the BBI Steering Committee. As to the issue of the legality of the BBI Task Force and the Steering Committee, and as explained above, the Task Force and the Steering Committee were born out of noble intentions of His Excellency the President. Both were ad hoc committees appointed by His Excellency the President for purposes of advising him on the discharge of his constitutional mandate in fostering unity in the nation. The question of illegality of the BBI Task Force had actually come for consideration before Mativo J, who had considered this issue and had come to the conclusion that His Excellency the President acted within his powers under Article 131 and 132 of the Constitution. This was in the case of Third Way Alliance. I've also had the advantage of reading the